This is talking about insurance now.
So here, and I haven't put any of the text of the actual document here because, first of all, and I do this every day, insurance is probably the most boring part of the agreement. But I will say this, and this is not in anything in deference against the AAA. They have had insurance language in all their documents because it's important to have everybody insurance. If you're out there practicing architecture or a contractor, make sure you have your insurance. And I could tell you horror stories of my clients that didn't. But that's the first thing, and the AAA recognized that.
We'll do that as another podcast
we can
later.
have the lessons learned podcast. But the important thing here is what the AAA recognized is and especially in the A series, the language they tried to put in pretty good, robust language. But the insurance industry is so rapidly changing that they couldn't keep up with the language. So what they did now is they have a little bit more detail in saying, for the insurance, we're going to have, you need to get your professional liability and a few more comments that are general. So the architect has a guideline, the owner has a guideline, but not real great detail. When we get into A201, I'll talk a little bit more about how they handled it for that, because insurance can even be more important on the construction side of it. But at least what we've done here is we've beefed up the insurance provision so the parties, again, can have that discussion up front.
Right. So we've got a couple questions in. One of them that a number of people have asked is, will the ARE test us on the 2007 or on the 2017 version? The way that the questions get developed over time, it takes a lot of time to test out different questions and build them up. So I would expect there will be 2007 questions for quite a while. However, there will start to be 2017 questions, and I'm sure there already are some in the NCARB body of questions, but you'll get both. You shouldn't get too many questions that are like, they're not going to try to trip you up between, you didn't know that it was a 2017. Like, the questions are going to be sort of general to a certain degree. Do you just sort of understand the type of question, the type of issues that the contract is really covering? The thing you want to be looking for is those kinds of issues that are easy to ask a question about and are meaningful to young architects. So something like the change in BIM, like, correct. Do you have insurance? How do you express insurance? Are we going to do a sustainable project? All of those things. And then, of course, all of the instruments of service, standard of care, right. All of those kinds of terms that we had. We had one other quick question here. Somebody was, I'm trying to read it here, Muna was wondering, is the change in, with the BIM model thing, is that similar to the fact that when there's like using the word indemnify in the future, like when a owner takes the drawings and goes and does work without the architect's knowledge, there are certain terms that are built into the contract. Is it sort of similar to the way that was done in 2007? Is that how the fact that they have said that you are sole liability or sole responsibility without liability to the other parties, that means you're taking it on your own. Now, if we can go back real quick on that slide to see, because I want to make sure that whether they have actually indemnification language in there. So in this version here, it says it's without liability to the other parties, but it doesn't say you need to indemnify. Indemnify means you are stepping in and you are protecting that other party. So it hasn't gone so far as when the owner takes the architect's drawings and uses it on a project with the architect's response overseeing it. So here it's just saying you're doing it at your sole responsibility and nobody else has liability. So but it doesn't say that the owner, let's say the owner's taking it. That extra. Correct. So, which is built into the regular part of the contract. Yes, and one of the reasons why is because anybody can deviate from BIM. In the indemnity has to be contractual. So that's why if the owner takes the drawings, there's the contractual indemnity. But if the contractor deviated from BIM, he doesn't have to provide indemnity due to the structure of the way the law is put together. And that's another lecture for my students and not for you guys. That's a longer one.